permission. But item 32, impugned order is an amendment carried to the rule, my lord, but by mistake my colleague morning properly not represented. Impugned order, which is challenged in this matter, is an amendment carried to a rule, statutory rule. That's why, my lord, the matter came before the bench. But along with batch, my lord, it went to a single judge since my junior could not represent.
We have even signed the orders. We have even signed the orders. It was repeatedly asked, and
I told him that.
we repeatedly asked to show any order which has any statutory backing or statutory force.
In fact, impugned order only.
We have already signed it. You have to now apprise that bench where it will go. You are not remediless. You can apprise on that day. You can file an application. We have already signed it.
It's pre-lunch. I was reading Balaji Badavath.
Para 23.
After para 23 minutes, kindly come to para 27. Yes, I left the honorable bench with the idea that the very purpose in that judgment of Chattar Singh is counterproductive in the manner in which they are implementing it. I'll show your lordships how it works arithmetically. Come to para 27 in the meantime.
Just a minute. Why these advertisements are coming here? Why advertisements are coming? Bell rang. Sorry, please continue.
Para 27.
Yes.
We have been informed at the bar that 12 handicapped people have appeared at the main examination. It would be possible to fill up the post even from that category of candidates. So they were looking at a fact scenario wherein they found that the number of vacancies, the number of seats were all being filled up. I'm not trying to bring down or the ratio laid down. I'm going ahead with saying that this is the ratio laid down. But even within the ratio, there are various other aspects of the matter that they have not considered. One. Secondly, Balaji Badavath has moved on.
That is 208.
208.
Yes.
1 minute, I'm sorry. I told your lordships that I want the counter where they justify the change. Uh, They said that the interview is done away. One of the questions your lordships asked us yesterday was whether they have even an interview or is it only the written test. Your lordship may kindly go to page 168 of that paper book.
That is GO 55.
Here. Paragraph 2.
Yes.
Government have issued orders wide GO 11th read above, dispensing with interviews for all TSPSC examinations, including so-and-so and other recruitments, so-and-so. This is only to show your lordships that there is no interview. There is a preliminary and then there is a written test.
I don't think they are disputing it.
No, they are not. They are not. But I just wanted to show your lordships from the record that that is what it says. Millards, now the total one argument that came up in between, punctuating our arguments, was that this challenge to bring the matter before your lordship was a smoke screen, that there was no actual challenge to the rule, because the rule is hunky-dory and fine. May I now take your lordships to the rules? Show me the rules. Section Rule 22 E.
Which rule you are referring to?
The subordinate service rules. The book of this. Isn't it?
Yes.
Millards, out of, if your lordships read E, B, the last one there, out of 50 appointments to be made on the basis of open competition, your lordships have that, Millards? Rule 22,
Small
I think
b,
it's a
small b.
Small b. That will be at page 38 of that book.
Yes.
Small b. Out of 50 appointments to be made on the basis of open competition, 3 appointments shall be reserved for direct recruitment of the persons with disabilities. Therefore, the rule introduces vertical reservation to a category which the Supreme Court said cannot be by vertical, can only be horizontal.
But this rule is under challenge before us.
Yes, that is the rule which is under challenge. And I'm also, to show that it's not just smoke screen, I'm going to show your lordships how the rules are contradictory to themselves. Now kindly come to the next page, to Rule 22 at page 44. This would be Rule 22 I. Capital E, small I, page 44. At no selection for recruitment other than any limited recruitment in accordance with the provisions of Sub-Rule G, the number of reserved vacancies, including additional vacancies reserved under H, shall exceed 56% of the total number of vacancies for the selection. And all vacancies in excess of 56 of the total number is made, but shall, notwithstanding anything in this rule, be treated as unreserved. Firstly, the rule moves away from the 50% rule. Then it says all reservations, even assuming they can move out of 50 in extraordinary circumstances, 56 is what they say, no empirical data before this honorable court justifying above 50%. Thirdly, they say 56%, and now see the calculation.
Rules of 96, they are in the statute book since 1996.
Correct, but I come to challenge it only when it comes to affect me.
Not on that point. The question is whether there was quantifiable data or not as per M. Nagaraj or all.
Yeah.
That only when their counter is filed, it can be.
I have a problem there.
Yes.
Now, as of today, your lordships rightly observed in the beginning, your only lordships are looking at an interim relief. I am showing today that there is this kind of a material. There is no data because your lordship would not see it from 1996. Your lordship would see it from the last time these were held. Or even if it is seen from 1996, it is the onus of establishing. Well, the full bench of our court, speaking through Justice B.B.S. Rao when it came up to Muslim reservations, he said, once I establish that there's a prima facie illegality, the onus of establishing that it is in accordance with law shifts in the cases of classification.
There's no quarrel on the point. The question is whether there exists a quantifiable data or not. That can be seen only when counter is filed.
Counter is filed. My lords would now see that the total reservation is 58%. SC 15%, ST 10%, BC 29%, and persons with physical disability 4%. Now, Section 22EI says the outer limit is 56. Notification says 58. 58. 50 goes to 56 goes to 58. And my lords, in places of public employment, every seat, every job is a total denial to somebody.
Yes.
And if your lordships go back to the impugned order, they do not trace their power to a constitutional provision. They trace their power to Section 34 of the Disabilities Act. Like Krishnamurthy in the pre-lunch session was telling your lordships that right or wrong, the government is now foot and mouth bound by the content of the GO. They cannot justify it by anything else unless they trample on Mohinder Singh Gill and the multiple judgments that have come after that. I'll just for purposes of academics show your lordships one of the most recent judgments reiterating Mohinder Singh Gill by our own High Court, by a division bench presided over by Justice Bhuyan as he then was.
We are consistently following it.
Obviously.
That will be more recent.
Yeah, I beg your pardon. I beg your pardon. So I won't labor them. But suffice it is to say, foot and mouth, they are bound by Mohinder Singh, they are bound by the GO. The GO says their point of reference is the Disabilities Act. The Disabilities Act can't overrule the constitutional dicta, which is interpreted in Indrasani saying 50 is your borderline. The Lakshman Rekha is 50%. You can't go beyond that. So the argument that it is a smoke screen, that it is done for this purpose, does not augur well. Well, I'll also ask myself this question. Let's for a minute examine whether it's a smoke screen. The argument was, I should have gone before the single judge on one aspect of the matter, namely 1:50. Unfortunately, my lord, may I draw your lordship's attention to my pleadings in the reply that I have filed. That paragraph. Rejoin that paragraph on. No, the one on, I can't go to multiple cases. End paragraph. Yeah. Last paragraph. Last paragraph. Is this the one? No. Where is the paragraph? May I take your lordships to page 38 of my reply?
That is
Reply in WP number 26038. Rejoinder to in WP 26038.
that is in the record of. It is a rejoinder to public
the
service.
counter filed by the public
Public
service.
service.
Provisions of Order 2 Rule 2 CPC bar the maintainability of multiple suits for same cause of action, since the notification and the examination pertain to the same set of notified posts under Group 1, dated so-and-so. Filing separate writ petitions for each issue is not maintainable.
But nobody has raised this objection.
The argument was from the government that we were just coming to a division bench on an issue which is not primary in our challenge. The challenge to the numbers. The total number of vacancies are 563. In the ratio of 1:50, the total number of people to have been called is 28,150. 28,150.
They are actually called.
Actually to be called in the ratio of 1:50.
Yes.
Actually called is 31,382.
352.
82. They explain this additional 3,232 to the proviso in the impugned GO.
Yes.
Which says if there is a short before,
How much is the percentage?
62%.
Yes.
The open category is 209. The reserved is 354. Open category is 309. Adding to 563. Now the candidates called is 17,770. 17,700. For the reserve, see? Shortfall they said and made it 3232 additional. Therefore, the total candidates called is 17,700. From the total of 31,382, if the number of persons called for the reserved category, 17,700 is mine, deducted, the total people now called for the open category is 13,682, which works out to a ratio of 1:65. So, effectively, what have you done? You said to ensure I want it at 1:50, I made a rule saying I will not look into reservation. I'll go by 1:50. What do? You call it at 1:65. And you pep up the total number of people in the reserved categories. And while pepping up the people in the reserved categories, at the cost of repetition, I reiterate with emphasis, what are you doing? When you say 1:50, you're taking one SC candidate and getting 50 people, whereby this candidate at 1 would have gotten under the regular list. So the proportionality of the total number of people coming in the ratio of 1:50 in the reserved categories falls down. Because it has gone up here by 1:65. The total numbers will have to be a constant. So where does this number adjust itself? It adjusts itself in breaking up the entitlement of the SC/ST candidates.
Yes.
This is our page. Yes, I want their page. This is your pagination of the counter. My lords, in the counter affidavit filed by them, which I wanted to show your lordships, I sought leave to come back to that. Kindly come to the counter filed by them. It starts at page 199 in the paper book filed by Mr. Madan Mohan's instructing counsel.
Yes.
This counter affidavit, kindly come to its first page. I, Anita Ramachandran, wife of G. Srinivasa Subramanian, so and so, do hereby solemnly and sincerely affirm and state as follows. Come to their internal page 17. This is 21. Para 34.
34.
30.
Yes.
Now, in this writ petition, my lords, to reiterate the background, the earlier GO, that is GOMS number 55, which was under challenge, which provided for 1:50 inclusive of reservations. That came up for challenge. They said that was the right thing to do. They said, while we call for people from the prelims to the written test, they must be in the ratio of 1:50. Let us look at their justification. Regarding the judgment referred to by the petitioners in Jafar Sahib versus so-and-so, it is submitted that the facts of the above case are different from those obtained in the present. The recruitment referred to therein was conducted by the APPSC in the combined state, wherein the posts in Group 1 services was statewide, and selection for these posts was also based on statewide. Further, the then recruitment had 3 stages of selection: prelims, main, and oral test. The marks secured by the candidates in preliminary were counted for the purpose of ranking for final selection. The Public Service Commission then called for candidates for main examination community-wise. However, such method by APPSC was not supported by rules. The method adopted by APPSC was different from the government policy. Similarly, in APPSC versus badavath, the Honorable Supreme Court upheld the policy of APPSC picking up the candidates without following community reservation. Whereas, from here, my lords, whereas, in the changed circumstances at this distant point of time, the government of Telangana came up with a new policy, wide GO-MS 55. Moreover, the context in Telangana is quite different from the other states. The state of Telangana was formed newly. The posts under Group 1 were converted from state cadre to multi-zone. No other state in the country is comparable with the state of Telangana on this count. 95% of the reservations are provided for local candidates. The state of Telangana consists of 2 multi-zones, one comprising 19 districts and 2 comprising 14 districts. Each multi-zone is distinct and different. Therefore, a new policy was devised by the government under GOMS so-and-so, ensuring equitable opportunities for all regions and communities, and hence the pickup was undertaken from preliminary. This is their reasoning. Fast forward, now this counter is sworn to on 11th July 2023. Seven months down the line, there's a U-turn. And what is the U-turn?
Yes.
I have no problems with conceding to the fact that the government is empowered to change its policy drastically from an earlier policy. I have no difficulty there. But they stated in their GO that the basis for changing, for bringing in the new rule is the judgment in badavath, which they themselves say is not relevant to the facts of the case.
That's all.
In that view of the matter, my lords, I think, my lords, just one more aspect, my lords. Your lordships, as your lordship said, are dealing with the interim order part. My lords, normally your lordship would say, let an examination go on, let it be subject to the result. We will not halt it, etc. We come with the lubrical thrice. Like with Caesar, they were twice rejected. Once they withdrew it on the ground that the paper leaked. So all the candidates whose ink in their pens were ready to scribble on paper were sent home packing. First time. Second time, this High Court faulted it and said, start your exercise again. The consequence of that, Mr. Krishnamurti has argued, I will not repeat it. Therefore, today the balance of convenience lies in ensuring that in the case that your lordships are directed in Madhya Pradesh, they have to conduct the re-examination all over again. To whose benefit are they doubling the cost of the examination, the challenge to the candidates? There's a lot of trauma that a candidate goes through. When I wrote an exam, I was scared. I didn't want to take one. So my argument before your lordship would be that the balance of convenience is also with the writ petitioners. Once they are able to show that the inconsistency with which they have acted, the numbers tell lies, they are in violation of Supreme Court judgments, which are the law of the land, and the impugned GO itself is of suspect nature. In that view of the matter,
Petitioners,
obliged for this.
anybody else for petitioner? Concluded.
Yes.
State.
Sorry. Firstly, my lord, I would like.
Yes.
But as I have been pointing out, my lord, from the beginning, my lord, if your lordships have noticed, the entire argument is based on my lord, challenge to 29. The entire argument so far, my lord, since yesterday, what all they have argued, except for a little time on the rule,
Yes.
except for a little time on the rule, that is Disabilities Act, my lord, being vertical and horizontal. But their entire argument is against, my lord, in respect of GMS number 29, which is an executive instruction which have been, my lord, agitating since the beginning. That their very purpose of this filing of these writ petitions, my lord, is to, my lord, agitate their issue on GMS number 29, not the Disabilities Act, not the rules of disabilities. But the disability, my lord, the prayers I may be permitted to read. I will not take much of your lordship's time in respect of repetition, my lord, already. 26038, your lordships may kindly.
No, this P5 is a statutory provision which is under challenge.
My lord, I'll take your lordships.
That is GOBIS 96.
Yes, my lord. But the first prayer, my lord, declaring amendment to Rule 22 2AB, Lord, 2AB of State and Subordinate Service Rules, your lordships may kindly be taken. Lord, your lordships have got it, my lord. Writ petition number 26038. Lord, your lordships may kindly be taken to page 37, the prayer. But before that also, my lord, I would only take your lordships through para 3 of the affidavit, page 9, my lord.
Yes.
What is their primary interest to come before this honorable court? Your lordships may see, my lord. Their grievance is here. I submit that petitioners are seeking to declare GMS number 29. This is their para 3 of their affidavit. Page 9.
Yes.
I submit petitioners are seeking to declare GMS number 29. General Administration amending GMS number prevents reserved categories who obtain marks so and at all stages of selection as being illegal, arbitrary and contrary to law laid down by Honorable Supreme Court in various cases. That they go and issue consequential direction directing the respondents to apply rule of reservation for all candidates independently 1:50. That they go. There nowhere, my lord, the rule challenge where it comes in their prayer in the affidavit also, my lord, is to declare the action of respondents in treating special reservations with physically handicapped ex-servicemen and so wide GMS under the rules 22A, capital A of the Telangana subordinate service rules instead of treating horizontal. This is how their initial argument and their understanding and their original grievance is also against 29. Now your lordships may kindly see page 37, their prayer.
Yes.
That the casualness, my lord, the rule has to always be specifically, Lord, challenged. Lord, may I request your lordships to kindly be taken to the rules also, my lord, rule 22(2)A. Because, my lord, if your lordships would see, declaring the amendment to the rule 22(2)A and B, lordships got it, my lord, page 37 of the Act.
There is no B.
No, my lord. 22A, your lordship, 22
Small A.
A, my lord, small a is there, my lord, the bottom.
But there is no small b.
Small b also is there, my lord. Your lordships would find at the bottom of the page. Next page, bottom. This is nothing to do with disabilities. This is nothing to do with the, my lord, except the last line. Out of the 50 to be made on the basis of open competition, 3 appointments shall be reserved for direct recruitment with disabilities. But the challenge that they were making is horizontal, vertical reservation. My lord, nothing forms part of 22(2)A, 22(2)B. Perhaps, my lord, they wanted to challenge 22(2)E. Your lordships would, my lord, kindly be taken to, my lord, page 39E, 22(2)E. And then your lordships may kindly be taken to page 41. Subclause 2. That's where in the second cycle of 100, the point shall be reserved blindness, hearing, locomotor, and so on. The rule itself, my lord, that's where, my lord, I was trying to project. The casualness in challenging the rule also may be kindly looked at. Their very object was to come for 29. Their arguments has been on 29. Lord, the smoke screen, Lord, I would only say, I don't have to say much, Lord. provision which they have challenged before your lordships is not what they are intending, probably 22(2)(e)(2), Lord, where it talks about the disabilities. Then your lordships may kindly be taken to the next page, Lord, I'm sorry. The 6th to 31st, Lord, this has been amended in GMS number 96. Now, GMS number 96 or this amendment, my lord, is issued in pursuance of section 34 of Disabilities Act 2016. The paragraph extract has been taken from there and placed here. There is no difference of words. My lord, I request, my lord, Disabilities Act 2016.
No, you are reading page 38.
I'm sorry, my lord. Page 38 is the prayer. 22(2) small a small b.
Yes.
My lord, and the lordship would see, my lord, A and B. My lord, perhaps they were wanting to challenge 22(2)(e)(2). They were not specific in their challenges, my lord. 22A and B does not talk about disability roster points or anything.
Meaning, you are saying that this small b is borrowed from Disability Act.
No, my lord. My respectful submission is 22(2)(e)(2). Not at page 40, your lord, 41. 42 of this blue Roman 2. 42.
Second cycle.
Yes, my lord. Second cycle of 100. The following point shall be reserved as follows. Perhaps they intended to challenge this. They ended up challenging only those two. And your lordships would, my lord, kindly be taken to page 42. The 6th, 31st, 56th turn of each cycle of 100 vacancies shall be allotted to blindness, hearing impaired, so and so as stated above. And where the qualified and suitable candidates are not available from among them, the turn allotted to them in the unit referred to above shall be carried forward to the succeeding recruitment year for being filled from the same category. If in that year also qualified candidates of the same category are not available, the same shall be notified for being filled up by interchanging. But there is a carry forward rule in disabilities under section 34 of the Act. Sorry. I'm just taking this because before I take your lordship through the GOMS number 96, Lord, we have raised the power, Lord, and we were obligated, not duty bound to frame this in pursuance of section 34 of the Central Enactment. Lord, this is the Central Enactment 2016 Act of Parliament. Section 34.
Yes.
It talks about reservation. Every appropriate government shall appoint in every government establishment not less than 4% of the total number of vacancies in the cadre strength in each group of posts meant to be filled with persons with benchmark disabilities, of which 1% each shall be reserved for persons with benchmark disabilities under clause A, B, C, and 1% for benchmark disabilities under clause D and E, namely so and so. Provided that the reservation in promotion shall be in accordance with the instructions as provided as are issued by the appropriate government from time to time. Provided further that the appropriate government, in consultation with the Chief Commissioner or the State Commissioner as the case may be, having regard to the type or work carried in any of the government establishments by notification and subject to such conditions, if any, as may be specified in such. Lord, now 34(2) is the enabling power to the state, where in any recruitment in any year, any vacancy cannot be filled, not carry forward, cannot be filled up due to non-availability of suitable persons with benchmark disability or for any other sufficient reasons. Such vacancy shall be carried forward in the succeeding recruitment year, and if in the succeeding recruitment year also suitable person with disability is not available, it may first be filled by interchange among the 5 categories, and only when there is no person with disability available for the post in the year, the employer shall fill up the vacancy by appointment of a person other than person with disability. Lord, this is the exact this is extracted in Lord, the rule your lordships may kindly see, 22 to E, that page, page 42. Your lordships will get 4 lines, where qualified and suitable candidates are not available. Top 4 lines, 6th, 35th, 31st and 56th turn, your lordships got it. From there, 4 lines down, where qualified and suitable candidates are not available.
Yes.
From among them, the turn allotted to them in the unit shall be above carried forward to the succeeding recruitment year for being filled up by the same category. If in that year also qualified candidates of the same category are not available, the same shall be notified for being filled up by interchanging among the categories. Only when there is no person with disability of any of the 3 categories or the post, the vacancy shall be filled up by employer by appointment of a person other than person with disability. Therefore, my lord, challenge to the rule, my lord, which is in consonance with the central enactment without there being a challenge to the Act, section 34, my lord, under which, my lord, provision this rule has been framed. But I respectfully submit, my lord, this challenge may not be right, my lord. They have to challenge the Act under which we have framed the rule. Now, your lordships may kindly be taken to GMS number 96, which is the rule, my lord, we framed. Page 152.
Yes.
In exercise of, my lord, on the top, in the GO 6 read above, comprehensive orders were issued in consonance with the provisions of section 34 of Rights of Persons with Disabilities Act 2016 and in supersession of the orders in GO 2nd, 4th and 5th read above specifying that necessary amendments will be made to the Telangana State and Subordinate Services. Accordingly, following notification. In exercise of the powers conferred by proviso under 309 of the Constitution and all other powers hereunto, the Governor of the Telangana hereby makes the following amendments to the State and Subordinate Service Rules, General Administration, so and so. In Telangana State and Subordinate Service Rules, in Sub-Rule 23, the following shall be added. Person with benchmark disability means a person with not less than, that. Then in second proviso, Rule 22B, is now modified from 3 vacancies to 4 vacancies. Earlier in the old rules, it is 3. In 2016-18, they made it to 4 because now we have 5 disability categories. Now we have 2. Then your lordships would see, the next page 153.
The only difference is that in place of 3, it is now made 4.
4 because earlier they were
These clauses are there.
same to same. And the reason, my lord, now the difficulty we are at, these vacancies, my lord, have to be notified for a benchmark disability. And if such benchmark disability person is not available, then you should carry forward for the next year for the same benchmark disability. That is as per section 34(2). And if such person is not available in that benchmark disability, then you shall open it for other disabilities. Only when no person is available, it comes to open. Therefore, these vacancies, my lord, I call it vertical, horizontal, whatever they are trying to claim, my lord, will at any point of time will not be available for open for any other candidates other than disabilities for the next 2 years minimum. And they can be only said to be available only if there are no disability candidates after the 3rd year. Now the writ petitioners in the first writ petition, none of them are disabled. In fact, I am not sure, my lord, in all the writ petitions, I am doubtful if any of the disability candidate is before your lordships. But they are placing a challenge to a rule which is framed in consonance with the Act of Parliament.
Yes.
And they want this, my lord, this is a carry forward vacancy. They can never have a claim against such vacancy because these are all carry forward.
Yes.
Therefore, my lord, my respectful submission in the first ground, my lord, these writ petitions, my lord, without they having the locus, for the simple reason, none of them are disabled, none of them are placed before your lordships, how their rights are affected, how this rule has come in the way of their selection into the preliminary round, how they can make a claim or right under this particular rule, my lord, how they have lost their right to selection. There is no such, my lord, argument that has been advanced, at least to my, nor has been pleaded, except saying, my lord, that this rule has to be applied horizontally, vertically. it has been applied vertically, it should be horizontal. Except that, my lord, there is no other pleading which they have stated how their right is affected. My other ground, my lord, is GMS 29, as I have already been saying, my lord, it's an executive instruction. But already there has been challenge before the other bench, my lord, there is contest that's going on.
No, that is 55, not 29.
29 also. 29 also there is a challenge here.
Whether 29 is also under challenge?
Yes, before the learned single judge.
I'm not.
Three requisitions are pending. We have 5 counters there. We are contesting.
29 is also under
Yes,
challenge.
29 alone was challenged before the learned single judge. '29 also there is a challenge here.
Whether 29 is also under challenge?
Yes, before the learned single judge.
I'm not.
Three requisitions are pending. We have 5 counters there. We are contesting.
29 is also under
Yes,
challenge.
29 alone was challenged before the learned single judge. Also there is a challenge here.
Whether 29 is also under challenge?
Yes, before the learned single judge.
I'm not.
Three requisitions are pending. We have 5 counters there. We are contesting.
29 is also under
Yes,
challenge.
29 alone was challenged before the learned single judge.
How many days it will take written examination?
7 days.
7 days. And ordinarily, how much time it takes to declare the result?
2, 3, 8 days.
Better able to tell us. How much time ordinarily it takes to prepare result?
Whereas I'm told there are 210,000 papers to be. 210,000 odd.
3 months is what I have been instructed. Yes. Yes. So declare the mains results. This is the mains exam which is descriptive. 3 months and descriptive. Yes. Descriptive, not multiple. 3 months. 3 months. Examination is descriptive examination, not multiple. Only preliminary exam is multiple choice. Preliminary exam is descriptive. It is descriptive, yes. Yes, descriptive.
But insofar as we are concerned, my lord, we'll file, my lord. Already last occasion itself, I represented that the counter was being filed. My lord, there was some delay. My lord, 3 days, my lord, I'll get that file being filed. The whole difficulty, my lord, now the schedule has already been given. Hall tickets about 85-90% has been downloaded. Exams are scheduled from 21st. The notification is given in February 2024. All through they had this, that these are the regulations. This GO29 was notified from day one. It's not as though, they came in today. That GO29 which they are referring to, the executive instruction of 1:50 is notified before the notification, and it has been referred in the notification from 19th of February. They participated in the notification. They have taken the preliminary exam. They did not come within the zone of pickup for the final examination. But only after that they have raised this.
I want the Jeevan Reddy judgment. I've been asking what included is ducking.
Even
where are all those judgments that they showed me that day?
It's not factually correct, my lord. I have stated petition number 4. That he admitted in the mains. He also challenged because one of his chances will be diminished. In fact, in the reply also, para 14, I have stated so.
Petitioner number 4 in one writ petition is qualified. Stand corrected. Rest all.
Second petition in my case is also qualified.
Lord, in so far as rule challenge is concerned, my lord, I need to file a counter, my lord, because this is as explained, my lord. Their primary challenge on the rule is only about application, my lord, horizontal and vertical. But, my lord, there.
Yes.
So we don't know about whether we clear. Yeah, cleared in the sense that we got minimum marks.
There is no qualifying mark.
No qualifying marks.
No qualifying mark. The topmost people have been picked up from top to bottom in the order of merit. There is no cutoff mark, my lord, for being qualified. So, my lord, every person who were in the zone of pickup are eligible for both open vacancies as well as reserved vacancies without there being any discrimination, my lord. Every post is available for all the persons. The argument, my lord, of them saying that certain reserved categories will be losing their merit in the open, my lord, is all far-reaching, my lord. All the persons who are now picked up under 1:50 for reserved are eligible for open vacancies also. That is one thing which we would want to clarify, my lord. And the GO29 which they are referring to, my lord, we have specifically explained, my lord, that how the pickup has happened. Earlier, GO55 talks about rule of reservation. As per rule of reservation, that words have been deleted. Now in the order of merit, 1:50 is being picked up. Any reserved category person, my lord, where there is shortfall of candidates, it's not falling within 1:50, my lord, they'll be picked up from bottom, the order of merit. But the system is very foolproof, my lord, fair and just and equitable. All persons are being given an opportunity.
Jeevan Reddy saying
that insofar as the GO29 is concerned, and rule is concerned, I would like to file a counter at this stage. Now, my lord, exams are to be held up, my lord. 3 to 4 days, my lord, I will get the counter. Very well.
Just answering him, my lords, the first one was he complains of us being casual. Yeah, this is the pot calling the kettle black. Look at the manner in which they issue the GO. They're saying that we people who are unemployed are casually challenging it. He doesn't read the prayer. He tells this honorable court that we have primarily our challenges to something. We've incidentally challenged this. Obviously, he was not paying attention to how I showed your lordship how this kind of an enactment will have to
Para 3 itself is there. Para 3 which he read, he has not full read. Your lordship will see para 3 itself, your lordship will see. Para 3 which he read, he has been only read to the extent. There are a number of places we have searched. Yes, sir, we have searched. Your lordship, I kindly just para 3, page 10, my lord, declare the action that is a horizontal, etc. They we have stated. Then, my lord, your lordship, I kindly come to, my lord, the para 10 onwards. Para 10 is GSGO, this thing. 29, first is concerned, my lord, page 16, internal page 9 of the affidavit. I have extracted the amendments.
Where is that observation of G1 at the outset?
GO29 is para 10 onwards.
But in my-
Para, your lordship, para 9 onwards. I submit 55-24 issue deals with the scale of the pattern. 55.
29, blood, in my
90s.
case,
Then I said so.
specifically raised grounds, blood,
Well, that follows, my lord. I have
page
given the
number
pa-
30.
96 is the
blood,
rule.
in WP number 28488 of 2024.
My lords, may
Yes.
I answer it slightly differently? My lords? The reason is this. This entire exercise may be in futility because in Anil Gupta's case, Justice Jeevan Reddy said this, and I'll read it out to your lordships. He said, at the outset, we may mention a glaring illegality which has unfortunately not been raised in these writ petitions, but is self-evident from the decisions of this court. Under the revised notification, he goes on to the facts and then says, even if it is not raised, if it is an illegality which is so serious, we will examine it. In a case of very similar nature.
When a foundation is
The
there,
foundation
para
is-
19 onwards, your lordship, para 19 onwards, I've given that. I submit procedure now adopted by the respondents. Prior to that, my lord, page 55, in short list of the reserve count is unwarranted if the correct procedure is followed, respondent as stipulated 55, hence UMS 29 level to 6. I submit a conceptual shortfall as discussed in Dipendra Yadav versus Honorable Supreme Court is fact against the principles of the institution. The judgment highlights that shortfall of the concept of ensures the presence of the fixed 1:50 candidates in the list, but conveniently ignores those who are qualified on merit. As per judgment, approach undermines the reservation policy objective not segregating meritorious candidates from reserve candidates who should be included in the open category based on their performance. The concept of shortfall as applied in GOS number 29 overlooks the judgment, emphasizes separating the meritorious 21 also, your lordship, 21 and
Para
22.
16, 19, 20, 21,
All the paras have really dealt with, my lord.
21,
Blood, in my writ petition, your lordship.
23, my lords, which the argument that I had made is also there in para 23.
Blood, your lordship may kindly refer to blood WP number 28488 blood. No, grounds, blood, grounds. Ground number blood 127 blood. Page number 34, para number 40.
From the Physical Disabilities Act. That section. Because in reply, just one other.
Nana AG has not said why reason they changed from 55 to 29. No reason is given. Just saying the fair procedure.
Section 30.
I will not one. As far as the in the counter, I brought your lordship notice para 31 clearly stating open category they take the physically handicapped reservation. Rajkumar Daria will not clearly say it's too much. But yes.
And my lords,
It has not been followed blood in the blood preliminary examination. That is also the main question before your lordship. That's why we came up before your lordship and challenged it. 29 and we argued the matter. My friend said
And-
that it has not been specifically raised, it has not been argued. It is there very much.
the only other argument is, my lord, my friend relied heavily on section 34 of the Persons with Special Disability, the Act. Lordship may kindly read section 34 for my benefit yet again. my lords. Every appropriate government shall appoint in every government establishment not less than 4% of the total number of vacancies in the cadre strength in each group of posts. Therefore, 4% you're obligated to appoint. How? Not the question that's going up begging is, while you accommodate this 4%, are you doing it vertically or are you doing it horizontally? The apex court said that all reservations other than the constitutional reservations shall be horizontal. Therefore, to come back and say We are bound by, obligated by the Act. We are not so much obligated by the Constitution.
That's only to provide the reservation, not an enabling provision. Enabling provision, the state has to do under Article 309. It
Not
can't be
only,
different.
not one submission, not your lordship, your lordship, not at the right from the beginning, your lordship expressed that not only interim relief we will consider today. Therefore, we made our submissions with the interim relief only. Yes, Lord. So therefore, Lord, my learned friend says that we have not argued about the virus and all those things. Lord, it will take some time. He has not filed any counter. So therefore, Lordship kindly consider 21st is the examination for granting
We also suggested an alternative, that is, let them follow 55. That's what we said in the exam. That also you have to discuss. That's
much of it.
obliged.
Much of it.
Obliged.
We oblige for the patient hearing.
There is one more connected matter filed by the insurance company. MSCMA 2571.
They're not listed.
Not listed.
What is the number?
2571 of 2014.
You have written the number. As spread by Sri Ramakrishna, list with MSCMA number such and such of which year?
2014.
List in the next week.
Correct.
This is final hearing list. Any matter in which both sides are ready?
Case item 99. The last wanted to dispose of after hearings are completed, arguments also completed, other side taken test. That is suspension of the petitioner, not regularized under FR 54B.
Who is for the opposite party? High Court. It is High Court.
High Court counsel. My lord, last time he only took after arguments are completed. My lord inquired any order.
Is the council now? Now also is the council for High Court. A. Narendra Rudra.
What is the matter about? 99. Name of opposite counsel be reflect in the display board. Yes.
My lord, petitioner was kept under suspension, my lord, on 31st October 2019.
31st October.
2019.
Yes.
In pursuance of a charge sheet issued on 14th August 2019. 14th August 2019, charge sheet was issued.
14th August 19.
19,
Yes.
disciplinary proceeding was initiated. And on 31st October 2019, suspension order is issued.
You were placed under suspension
on 31st October 2019.
Yes.
My lord, ultimately inquiry completed and imposed stoppage of one increment without cumulative effect, my lord. Page 19 is the penalty order.
Minor punishment.
Minor penalty, my lord. Major penalty charge sheet ended up in imposition of minor penalties. And in the minor penalty order, they issued my lord suspension order also revoked. In fact, my lord, they have passed a special order revoking the suspension as per rules. But in the same order, my lord, page 19 it starts, my lord, penalty order.
Yes.
Page 20. They have passed a special order revoking the suspension as per rules. But in the same order, my lord, page 19 it starts, my lord, penalty order.
Yes.
Page 20.
Yes, sir. 2022. 29th.
Petitioner is working as academic assistant at third respondent college. He is fully eligible for the associate professor.
Use mic.
Instead of considering his name, Millard.
Where is Komat Reddy Venkataraman? You are representing.
No, I'm required for 2 weeks, Lordship, to file the additional counter.
Counter already filed, Millard.
Additional counter, they received a proceeding something else. I require me to seek the adjournment for 2 weeks to file the additional counter.
I requested the standing council to file counter, to file additional counter post on. This is the 29th.
Much obliged.
Wait, please a minute. The petitioners are family members of landlord Millard, who is no more now. Any one of the family members are seeking employment Millard under landlord's quota under GOMS number 98.
Counter is filed.
No Millard, no
That's what
counter
the
is
High
filed
Court
in
held
it.
that the petitioner was entitled to
And
full pay and
only thing
allowances
is
for
that
the period he remained under suspension. and the
Genco,
present
PS
case
Genco, who is appearing?
That para 21 also, my lord.
Yes.
Well, this is a relevant para. I am relying on this. In my case also, while revoking the suspension, they have not passed any order under response 54B. And when I submitted representation, they simply rejected with my lord without any speaking order. And as on today, my lord, my suspension revoked on 25th August 22. My lord, after 1.5 years also, they have not passed any order. And as per FR 54B, my B 5, my lord, I am
You have filed along with the petition.
Yes, the material papers, FR 54B, I filed, my lord.
Yes. You are relying on 5,
Yes, my lord.
sub-rule 5,
Yes, they relied also on the FR 54B file.
page 23.
Yes, page 23. And they have not complied with the 5 conditions. 5 says, my lord, they have to give a notice. My lord. 5 says, in cases other than those falling under sub-rules 2 and 3.
Suppose we set aside this order and direct them to follow sub-rule 5.
My lord, now it can't be, my lord, as per Supreme Court judgment.
Why you are going to 5? Therefore, we are.
I am not
asking you.
delaying, respondent is delaying. Sorry, my lord. I am not delaying, respondent is delaying. They have not complied. Yes, ma'am. They are 54. Yes, ma'am. Under 54, 1AB, they have to pass orders. 1AB, they have not complied. 54B, 1A, B. 54B, 1AB, which says, regarding the pay and allowances to be paid to the government servant for the period of suspension ending with the reinstatement or the date of the reinstatement, including as the case may be, whether or not the said period shall be treated as a period spent on duty. The competent authority must pass order under this. They have not passed any order till today. They say 5 is, my lord, applicable to me. Under 5 also, they have not issued any notice till today. I for Supreme Court judgment, my lord, that this.
Anything else? Anything else?
My lord, this Supreme Court judgment I am relying, my lord.
You relied on a Madhya Pradesh.
Our Honorable High Court judgment also I filed, my lord.
Where is that?
At page 25, my lord.
Honorable Justice Shavli's judgment?
Yes, ma'am. Page 25, my lord.
Yes.
Bottom. Learned counsel for the petitioner further contends that similar issue fell for consideration before this court in writ petition so and so, and this court disposed of the said writ petition while order dated so and so, observing as follows. I am of the opinion that the treating the period of suspension as not on duty while imposing a punishment of censure in the disciplinary proceedings will lead to imposing a major punishment. As such, the action of the disciplinary authority in treating the period of suspension as not on duty is unreasonable and against the good conscience. Therefore, that portion of the order dated so and so treating the period of suspension as not on duty as confirmed by the appellate authority is liable to be set aside and are accordingly set aside. Now the order dated so and so as confirmed by the appellate authority dated shall be read as that the period of suspension will count as period spent on duty for all purposes, including increment, seniority, promotion, etc. However, the order denying payment of anything over and above the subsistence allowance granted for the period of suspension shall stand confirmed along with the punishment of censure. And my lord's order also at page 27, that where my lords said, my lord, once major penalty charge sheet ends in imposing minor penalty. My lord,
Which is the relevant paragraph?
My lord, page 32, my lord.
Yes. Para number?
15, my lord.
Yes, kindly read it.
In the considered opinion of this court, if departmental inquiry aforesaid would have been concluded within a reasonable time, the petitioner's career progression in terms of grant of benefit of TB, PBS, etc. would not be hampered. The punishment of censure in this case would have been imposed much earlier than the date when petitioner was considered for promotion. Naturally, in that case, the said punishment would not have been a hurdle for the petitioner. This was the duty of the employer to ensure that the departmental inquiry is completed within reasonable time. Since the employer has failed to perform its duty, which resulted into capricious and arbitrary results, in order to prevent injustice, this court may itself pass an order or give directions which department should have passed or given, had it properly and lawfully conducted the inquiry. In order to complete justice between the parties, I deem it proper to direct the respondents to treat the punishment of censure as imposed in the year 1994 within 1 year from the date of initiation of departmental inquiry. The aforesaid punishment of censure, in other words, should relate back to the year 1994 within the reasonable period of 1 year from the date of issuance of charge sheet. In view of this finding, the said punishment of censure will not be an impediment for the petitioner for consideration of promotion, etc. Hence, the respondents are required to open the seal cover, which was adopted pursuant to selection held on so and so day.
Nothing to do with suspension.
The suspension, nothing to do, my lord.
Nothing to do with.
But the promotion meanwhile denied, my lord.
So that is not your prayer.
Yes, yes, yes.
If I correctly remember, we requested you to examine their Madhya Pradesh High Court judgment in Y.S. Sachan. Anybody brought it? O.P. Gupta is Supreme Court.
Yes. What I was just bringing to my Lord's notice is the reinstatement order of your Lordship, see, reinstatement order imposing minor penalty. But at that point of time, the clock would start for the petitioner to come before this court, challenge that she was not reinstated with by permitting her to also draw salary. What has happened now? Part of the order was complied with. She joined the duties. Subsequent thereto, she files a representation before the authority. Authority requesting to kindly see the order impugned now.
To decide the suspension period.
Yes.
Yes.
Because you are under a statutory obligation to decide it.
Yes.
Having joined, I would say, having joined this service.
Even after joining, because joining only gives him prospective benefits. So far, previous thing is concerned, 54B5 makes it obligatory on your part.
54, in fact, the impugned order, the Lordship sees the impugned order, but it said that we have rejected the request of the petitioner as spent on duty in terms of FR 54B. That is the rejection order. But just on the other court, but I was rushing to this court. I have just given a brief note of what my submission would be. A brief note by me, I've just passed on. First paragraph deals with the charges, but second, if Lordship sees. I have said so, relying on the Supreme Court judgment, petitioner is stopped from disputing the consequences flowing from the reinstatement order dated 20.
You are reading paragraph 2.
2 words. 25/8/22.
माइक चालू है कि नहीं देखिए माइक्रोफोन yes
Words. It is submitted the petitioner is stopped from disputing the consequences flowing out. It's on flowing from the reinstatement order dated 25/8/22. The petitioner by conduct accepted the correctness of the reinstatement order and acted upon it by rejoining his service. The petitioner has never challenged the reinstatement order 25/8/22. The Supreme Court
he is not disputing the reinstatement order. He is more than happy to be reinstated.
Yes, I was just bringing to my last order. That was the starting point for her to challenge the order, because part of her.
Where is this judgment? Let us read that portion of the judgment.
But,
is it on suspension?
Yes, sir. But this is
the suspension or termination?
But page 1, yes.
Yes.
But admitted para 2, para 2 of the judgment.
No, it's a case of termination.
Yes,
of language, not suspension. Here you are under a statutory obligation to decide suspension.
Yes, sir.
How this judgment will help you? Yes. Anything else?
But page 5 also you not page 5, page 5.
Yes.
Para 27. Para 27.
Para 12.
The petitioner cannot be allowed.
Para 27.
Yes. Page 5, it is page 12. Relevant page is page 12. Para 27.
Yes.
The petitioner cannot be allowed to act by accepting the one part of the order and decline to accept the other part of the order. It's contrary to the position of law. In effect, the person cannot be allowed to approbate and reprobate, as has been held by the Honorable Apex Court and so and so. The law does not permit a person to both approbate and reprobate. Principle is based on doctrine of election, such postulates that no party can accept and reject the same instrument, and that person cannot say at one point
one time the transaction is valid, there will obtain some advantage, to which he could only be entitled on footing that it's valid, and then turn around and say it would be void for purpose of securing some other advantage. Apex Court in case State of Punjab, where it paraphrased has been laid down that once the employees accepted the correctness of the order, they acted upon it, the same cannot be questioned by the concerned. I'm just stating what a part of the order was accepted by petitioner, having joined the service.
That is the only order. There is no other part. There is no question that part he is accepting. One part is missing. In your punishment order, you should have mentioned that how his suspension period is to be treated.
That was not said. That was not said. That's also remitted back to.
Why remitted back? This judgment of Supreme Court, where if you have not passed within reasonable time, it should be this Vijay Kumar Agrawal's judgment.
Yes.
You will follow Vijay Kumar Agrawal. And Honorable Justice Shawli's judgment is also there.
I was.
She such and such for the petitioner, she such and such senior counsel.
Balaji, madam. I couldn't be there, madam. I had to rest on the other.
You may leave.
I'm here. Okay. I was little late, I'm sorry.
No, it doesn't matter. She's such and such senior counsel for, with the consent finally heard. This petition filed under Article 226 of the Constitution challenges the order dated. The impugn order is at page.
Impugn order is at page.
Order dated 2010-23.
Page 14.
Impugn order dated 2010-23.
Yes, cross. 2010-23.
Whereby the first respondent, High Court is which respondent? Whereby the respondent High Court has rejected the representation of petitioner, claiming that period of suspension shall be treated as spent on duty with full pay and allowances. Next, we briefly stated the petitioner was served with a charge sheet dated 14/8/19. Petitioner submitted his written statement on 30/9/19. Petitioner was placed under suspension on 31/10/19. The inquiry report was submitted on 6/4/22. After obtaining petitioner's response to inquiry officer's report, the punishment order dated 25/8/22.
Yes, sir.
Dated 25/8/22 was passed, whereby his suspension was revoked and a minor penalty of inverted commas stoppage of one increment without cumulative effect for a period of 1 year was inflicted on the petitioner. The petitioner, in furtherance of this order, was reinstated and resumed back. Since the department did not pass any order regularizing the period of suspension, petitioner preferred a representation which was rejected by impugned order. Next, the learned counsel for petitioner submits that while reinstating the petitioner as per FR, both capital, FR 54 capital B in bracket small 5, the competent authority was under a statutory obligation to take a decision regarding the suspension period. Since no decision was taken for considerable long time, no decision was taken, petitioner preferred the said representation, which was erroneously rejected. The twofold submissions of learned counsel for petitioner is that in view of judgment of Supreme Court in Vijay Kumar Agrawal when a minor penalty is imposed and department has not taken decision on the, regarding pay and allowances, regarding grant of pay and allowances for the period of suspension, comma, the authorities are denuded from passing such an order, and inevitable consequence of the same is grant of full salary for the period of suspension. Dot. The second contention is based on the second contention is based on the decision of this court in WP number
Page 25, my lord.
6405 of 19, whereby wherein in a case where the petition is opposed mainly on twin grounds. Firstly, it is submitted that suspension period.
6405 call title, my lord. That is 6405 writ petition, call title it was
First
not.
title you may get
Yes.
6405. Firstly, it is submitted that the petitioner has accepted the part of the order dated